All rise. Lake Circuit Court is now in session. The Honorable Judge George C. Paris presiding.
You may be seated.
Good afternoon, Your Honor.
Good afternoon. Afternoon. Hey, Alex. My glasses are on my desk. We're in the matter of medical specialist versus MMDS Inc. et al. 45 CO1 1212 PL 129. For the record, who's here on behalf of who?
Good afternoon, Your Honor. Damon Lickey for the plaintiff, quality specialist. Anson Williams here on behalf of White Creek Associates.
Okay.
Scott Gainey on behalf of Northwest City Medical Properties Partnership and MMDS Inc.
All right.
Your Honor, Rep. Schwaber, on behalf of Dr. David.
Terry Connor, I'm here on behalf of Jack Whiteman, MMDS, and the Whiteman and Associates.
All right. Are we ready to proceed?
Yes, and I think we probably refer to Damon on some of these, but I think just to overview, we have a procedural matter, an agreement with the court looking at a status of a future date.
Okay.
And then setting a date on a matter involving the VITA and the discovery issue that's kind of been brewing, and I think Your Honor has probably seen some of the pleadings, but it's not set for today. And then the third and final item is taking up a summary judgment motion filed by NSPC as against MMDS, and we thought we could leave that to the end. So
okay. Why don't we do that? Yeah. All right. What's the agreements that you have?
Yeah, I think you've got exactly right, Your Honor. On the procedural items, as the court knows, there's been a stay in the case involving an indictment against Mr. Whiteman. There was recently a superseded indictment, so that proceeding is carrying on. As I understand, there was Connor trial in that criminal case is scheduled for November. I think the parties were thinking that perhaps a status conference in September would be timely, about 3 months down the road.
Okay.
To give us a sense of what's happening with that matter.
Okay. I want to give him a date, get a coordinated date, September.
While exploring the available dates of the court there, on the second matter, this involves counsel for the VITA, third party in the case. Ms. Amanda Metz, she and I have spoken. She gave me some of the dates that she was available for.
Okay.
Protective order motion that's pending before the court. That's now fully briefed. She's not here today. I did share those dates that she gave to me with other counsel. I think a couple of other counsel want to attend that hearing. What I suggested was that since none of those dates work for other counsel, that we'll exchange emails, communicate with the court by phone, and coordinate the date for that particular motion.
Okay, now that one will be before the September date? Or?
Yeah, we would anticipate it would be.
All right, give me a date, September for status.
But I was hoping.
I think a half hour.
Half hour.
I think so.
How's Tuesday, September 15th?
Good here.
That's good, right?
So I have to play, Your Honor.
Okay, September 15th, 1 o'clock? Same time?
Sure.
All right. Any other dates we need to coordinate right now?
I don't believe so, Your Honor.
Okay.
We'll call the court after consulting with the counsel on the evidence.
All right. And does that conclude the preliminary matters that we need to go over?
It does for the plaintiff, Your Honor.
All right, so now we have the summary judgment motion.
Yes.
Okay.
And I think we could, I don't think there's anything for the other folks here if they want to do.
May I be excused, Your Honor?
Yes.
Thank you.
Thank you, Your Honor.
Okay, Mr. Tauber.
There was a motion for protective order.
That one's they're going to coordinate a date on and get back. The protective order that's when you're going to coordinate, right?
Yes, Your Honor. It would be for that September date, but we'll call for it once we go on the parties coordinated. Thank you. Thanks, sir.
You're welcome.
The last matter report is ready. The NSPC filed a partial summary judgment motion on the counterclaim that defendant MMDS filed after this case was commenced. It's a fairly simple, direct motion, Your Honor. I actually prepared for the court's benefit for this hearing a small handout.
Okay. Yes.
And I have tendered one to you as well.
Thank you.
Thank you. Court probably recalls from prior hearings that the problem specialist is a physician group. It had contracts with two entities that were owned and controlled by Mr. Jack Whiteman. One was MMDS, which handles the patient bills for the physician group, and Whiteman and Associates was the accounting firm that would handle payment services, some other services for the physician group. This particular motion concerns only the portion of the counterclaim that MMDS filed. Under two agreements, one agreement in 1998 and one agreement in 2005, MMDS would receive certain payments from NSPC, nephrology specialists, as a result of patient billing. And if Your Honor would turn with me to page 2 of this handout, we've reprinted here the provision in that agreement that we're here to talk about today. In the 1998 agreement and in the 2005 agreement, the provisions worded exactly the same, Your Honor, except that the older agreement was for 7% of all clients' monthly net collection of fees for professional services rendered to patients, and the 2005 agreement was for 8.75%. Other than that, I believe those two provisions, those two agreements were exactly the same. The issue here today is a distinction between medical director services that our physician group would provide and treating physician services that they would render directly to patients. Under these agreements, as they were written and as they were applied by both parties throughout their entire business relationship, MMDS would receive a percentage of fees for services that were actually rendered to patients when these physicians were acting as treating physicians. They did not receive, and they were not intended to receive under the agreement, fees, a percentage of the fees when the physicians were acting as medical directors. That's the issue that is before the court, is whether MMDS is now entitled to rewrite the contract and now get a percentage of fees for medical director services. So the provision that we've reprinted here for the court's benefit on page 2 talks about the agreement allowing for a percentage of services rendered to patients. If Your Honor will turn to page 3, I'll explain how, both by law and by the facts, these two types of services are very different. Under law, these are Medicare and its governing regulations. A dialysis facility must have a medical director. So in this case, as Your Honor knows from third-party discovery, we have DaVita and other third-party providers who have these dialysis centers. They will enter into a medical director agreement with nephrology specialists or other physician groups for a physician to act as a medical director. That medical director is different than a treating physician, and the Medicare regulations recognize that. Medicare actually separates the conditions for coverage for those devoted for administration as opposed to patient care. So as a medical director, our physicians are providing supervisory or administrative services to the center, and they're doing it for DaVita or other third-party owners of those dialysis centers. They're not out and about treating patients directly. So they are essentially acting as an administrator of the facility, but not treating physicians, not treating patients.
Who pays them? DaVita?
DaVita then pays. So it's another distinction, Your Honor, that in the medical director capacity, they receive their payments from DaVita. In the role of treating physician, they would receive payments from either insurance carriers or from the patients themselves. So the contractual relationship, the relationship that they have is very different. We don't have to get into the weeds too much on this, Your Honor, because MMDS has admitted in deposition testimony this distinction between medical director services and patient services. So if Your Honor will turn to page 4, we have an admission from Mr. Jack Whiteman himself, who was the MMDS president. And as you see there on that deposition testimony we put it on page 4, it was asked, how is the 7% calculated? This is the 7% under the 1998 agreement for services with MMDS. And he made very clear these collections are anything other than medical director fees. And that's the precise issue. He admits that they were not covered, not included within the agreements between NSPC and MMDS. On top of that, Your Honor, if you turn to page 5, this is deposition testimony from MMDS's business administrator, Mark Rascosi. Now, Mark Rascosi was the gentleman who worked for MMDS who would actually prepare the billings on behalf of MMDS to be sent to W&A, Whiteman & Associates, for payment. So he was the one that was responsible for calculating the net collections amount under the contract between MMDS and NSPC. He was the one calculating these charges. And as Your Honor sees there, he makes very clear that in the entire relationship, the business relationship between MMDS and NSPC, he says medical director fees were not included as a component of the compensation that MMDS was to receive under the agreements that were had with NSPC. So not only did Mr. Jack Whiteman as president admit it, but we had the business administrator at MMDS who actually prepared the billing. If Your Honor will turn to page 6. There was a question posed by the NSPC physicians to Mr. Whiteman as to whether or not medical director fees were included under the MMDS contracts or not. Mr. Whiteman's assistant sent an email on January 6, 2010, and as you see there, she confirmed the long-standing understanding that medical director fees are not included in the billing percentage. So you have the president admitting it, you have the billing administrator admitting it, and now you have confirmation from MMDS itself that medical director fees were not included within the agreement. If Your Honor will turn to the next page, this is a reprint of something we've marked Exhibit 5600, Your Honor. This is a document that was actually prepared by MMDS itself. It is a calculation of the amounts that are due to MMDS from NSPC. And if Your Honor will look at the first 6 columns, the first column, of course, is the month. The next column included total receipts and medical director fees for the physician group in those particular months. And then you'll see the third column there, Your Honor, where MMDS has affirmatively taken out medical director fees. As Your Honor proceeds on through the chart, you'll eventually get to the 6th column, which is net patient collections. By the time MMDS runs the calculation on what it's due under the contracts, that this financial document shows that they were taking out medical director fees. Throughout the entire history of their relationship together, they were taking out medical director fees before they would bill NSPC. Their own financial documentation shows that medical director fees were not included as a component of remuneration to MMDS under these contracts. Just as a side note, Your Honor, you go to the very last column, these total invoices. These amounts tie out to invoices that were sent by MMDS to NSPC for services rendered under that agreement for billing services. So their own financial documentation shows they understood the medical director fees were not included in the compensation that they were receiving under the agreements. So you've got the plain language of the agreement, you've got the Medicare regulations that distinguish these two functions of the physicians. You have all the admissions of MMDS itself. For those reasons, I think this is a rather simple motion, and summary judgment should be granted on MMDS' counterclaim that it's entitled to additional monies because they didn't bill for a component or percentage of fees that were earned for medical director services. Now, Mr. Yannick has, of course, filed a response brief. We filed a reply. I'm sure Your Honor has read that. There are a couple things that trouble me with the response. Number one, Mr. Whiteman submits an affidavit that now is contradicting his prior deposition testimony. As Your Honor knows, that's a sham affidavit under Indiana law. I don't believe that he can now rewrite the contract in a way that he would prefer when, over more than a decade, everyone understood that medical director fees were not included as part of this contract. The second thing that concerns me, Your Honor, is they cite deposition testimony from Dr. David Oshbach. Dr. Oshbach used to be president for NSBC, our physician group, later departed to go on to other things. MMDS only cites a portion of his testimony. In the reply, Your Honor, we provided his deposition testimony wherein he said very clearly, I don't know whether the contract included medical director services or not. So his deposition testimony doesn't weigh one way or the other. He doesn't know how to interpret the contract. He admits that in his deposition. That does not create an issue of fact to conclude this summary judgment. There's other testimony that MMDS has cited, but as Your Honor reads that, I think the court will see that lines up with the distinction that the Medicare regulations establish in terms of these are medical director services and these are services rendered directly to patients. And so there's no reason in my mind, Your Honor, in MMDS's response that would preclude summary judgment. When it's all said and done, the agreement and all the admissions of MMDS make this a rather straightforward summary judgment motion. So we would request that the court grant a partial summary judgment order on MMDS's counterclaim with respect to its claim for additional remuneration for medical director services and fees.
Mr. Yanni?
I'm sorry.
Almost done. Thank you.
Yes.
A few summary items for you as well.
Okay.
I was some of the same materials that David just handed you on.
Okay.
We are looking at the same agreements here. We have many of the same facts that, quite frankly, aren't in dispute. But what we're here for today, Your Honor, is an interpretation of a contract, which is quite clear on its terms, which mandates, in my estimation, that this is not appropriate for summary judgment. And were there not other issues, other facts that are at issue, Your Honor, MMDS would be before you seeking summary judgment, certainly as to the meaning of the contract would do so. There are two contracts out there. There's one from 2005 and one from 1998. For our purposes here today, although the billing percentage differs between them, they are one and the same contract. So if you look at the terms of the one contract, it will suffice for the other. These parties had been in privity and had a relationship going back for many, many years, going back to the mid-'80s since this corporation was formed. And we move forward. There were billing agreements over the years. The most recent, the ones we're dealing with here in this court today, 1998 and 2005. But those contracts had two very important provisions that call our attention today. And I've provided those to Your Honor so that you might have them as well. Highlighted them in blue. There is Section 3A, which says that MMDS is going to do all of the billing for patient services. It says that client will employ MMDS to provide billing services for not less than all of the services provided by a client, unless otherwise agreed by the department. So that's the first clause that we're bringing to the court's attention. And then the second is Section 4A, also highlighted in blue. And it says, it gives the percentage that NSPC will pay to MMDS for providing these services. But what it goes on to say is that it will provide, or that it will compensate MMDS 8.75% for all of clients' monthly net collection of fees. And then here's the very key language: for professional services rendered to patients. And I think it's very important that we look at that clause very carefully, look at the words in that clause, and not read in words that are not in that clause. During Mr. Lecky's presentation to the court and in the briefs filed by NSPC, we keep seeing this word directly inserted. We listened to the transcript here this morning. We would have heard that term directly many times. And Mr. Lecky, a very skilled advocate, is trying to create a distinction that suggests these medical director services are not for professional services rendered to patients. And to help augment that argument, we keep seeing the word directly. We see it in the memoranda. There was the memoranda filed both in the motion and memoranda supporting the summary judgment brief, and then in the reply. But directly is not anywhere in the language. So we have a contract which is quite clear on its terms. MMDS provides all the billing services, and it provides those services for professional services rendered to patients, that its fee is based on that. Our MMDS acknowledges that this billing, these fees were not collected. Not collected all the time. So when Mr. Leckie cites to Mr. Viscosi's testimony, he's precisely right. Or Ms. Einter's testimony, an author of the deposition, did you bill for these services those years? No, they did not. And as to the contradiction, we'll get to Mr. Whiteman's deposition and affidavit, which are absolutely not contradictory, and I'll show Your Honor why. We're talking apples and oranges in many respects. But in Mr. Whiteman's affidavit filed with this court, he explains precisely what happened. And that is, no, they were not collecting these, their portion of the medical director fees. What happened is the issues arose between the parties. A termination was entered between MMDS and NSPC, under which they separated. And shortly thereafter, a lawsuit was filed by NSPC. At that time, Mr. Whiteman was caused to pay particularly close attention to all of the agreements that he entered in this relationship, and specifically those attached to the complaint filed by NSPC. And in looking at those agreements, the terminology, the express understanding of the parties was quite clear. And it was not the process that the parties had been following. But we don't have that argument by NSPC, Your Honor. We have a strict contract interpretation argument here before us today. If they want to argue at some point that this was our observed practice and that ought to be reason for deviation from the contract, in terms of the contract, we'll have to deal with that at a separate issue, separate motions, after the presentation of evidence. But we're not at that point. We are here strictly looking at the terms of a contract. And what Mr. Whiteman says in his affidavit is that I was caused to look at these contracts with the assistance of legal counsel, and I discovered, well, it should have been paid because medical director services are for patient care. And we can talk about that there was a supposed distinction made by Medicare. Certainly Medicare has a role to play in the area of dialysis, a significant one, because many of the patients that come into dialysis are there as beneficiaries of the Medicare system, at least the coverage. But there are many parties that appear in dialysis clinics that are covered by private insurance, self-pay. every mix that we have in any other medical practice. Medicare does not say, there is no regulation anywhere that says you aren't providing services to patients. In fact, if we want to look and see exactly what services were to be provided to patients by NSPC, where we need to go is to their actual medical director agreements that they entered with DaVita. These agreements don't appear anywhere in NSPC's motion, nor in their reply. But these agreements describe with particularity those services that NSPC was expected to provide as a medical director, or that its physicians were expected to provide. In the very titles of those sections, if Your Honor to turn to the second page of the service I gave you, there's something called the DaVita Medical Director Agreement Patient-Related Services. Paragraph 3 of that agreement is entitled Patient Treatment and Monitoring, and it goes through to enumerate what the physician shall do. And it very clearly talks about providing care to patients. This is not strictly a supervisory or management role, as would be suggested in the briefs filed by NSPC. And if we look also further, there's a further exhibit to the DaVita contract that each of the physicians signs on to, and it again provides the very express and clear terms of the DaVita agreement to which NSPC was bound to provide treatment for the care of patients. So certainly, NSPC was providing patient treatment under the terms of its medical director agreements, and its physicians were doing so as medical directors of the various clinics. Moreover, the physicians themselves, NSPC's physicians, have spoken to the type of services they provided. Most conclusively, we turn to Dr. Arfi, the very gentleman whose affidavit is attached in support of the summary judgment motion. But if we look at Dr. Arfi's testimony, if you'll turn, Your Honor, to the third page, I have excerpts from Dr. Arfi's testimony given at a deposition, and secondarily, testimony from Dr. Ajam, also a physician with the NSPC group. But Dr. Arfi acknowledged specifically that in delivering medical director services, those services constitute professional services rendered to patients. If you look at line 16, he talks, is that used in the treatment of patients? Is that right? It says correct. And he talks throughout his testimony here that he is providing services to patients. Contractually, they're obligated to provide those services, and NSPC's own physicians have so testified. We went through the agreement with Dr. Ajam. Dr. Ajam had the agreement before him and was asked, did you provide the services to patients as outlined in the agreement? Dr. Ajam said, yes. So, at the very least, Your Honor, I submit this as a matter for interpretation by the court, interpretation of a contract. But if we're going to look at the applicable facts in this case, NSPC's own physicians are telling us that these are patient services that they're providing. And I would submit, Your Honor, that gives rise to a disputed issue of material fact that would preclude the issuance of summary judgment at this phase. There may be others. There may be a course of conduct argument that NSPC will wish to argue someday to suggest that because we didn't collect these over a period of time that we're precluded now from asserting this claim, but that's not what they brought before this court. Your Honor, we, in our briefs and our motions, I won't go too much in detail, but there was subsequent billing from MMDS to NSPC for these services. And there were invoices submitted to NSPC for payment. Those obviously were not paid, and those were generated after the lawsuit was filed. So these were not, letting the court know, these were something that was done after the review with counsel, after the lawsuit was filed, giving rise, or giving Mr. Whiteman reason to really look at these agreements and the terms of those agreements, and thereafter those invoices were generated and sent to NSPC. And certainly there would be considerable sums due and owing. I think the principal sum would be, at that time, could be about in excess of $800,000. We heard reference to Dr. Ashbeck's testimony. Dr. Ashbeck was the president of NSPC, and while he was president, he prepared an affidavit that we obtained later through discovery. And in that affidavit, he testified that NSPC was obligated to compensate MMDS for medical director services in accordance with the two agreements, the 1998 agreement and the 2005 agreement. Now, Mr. Leckie, is certainly fair to say that Dr. Ashbeck was wrong. I took particularly, I had a bit of a wry smile as he said that, because it struck me as the pot calling the kettle black, because we've heard that we ought to listen to Mr. Whiteman, ought to be bound by what he said in a deposition. I'll speak very clearly about specifically what he said in a moment and what he didn't say. But Mr. Leckie would have us believe that Mr. Whiteman had the ability to interpret the contract, which I suggest is the domain of the court, but not in any of the parties, Dr. Ashbeck or Mr. Whiteman. But Mr. Leckie indicated that he wasn't competent to interpret the contract. Certainly I agree. But he's offered an opinion just as anybody else has offered an opinion, and he is he's an agent at that time of NSPC, that these medical director fees were part of the contract and should have been paid to MMDS. As to the suggestion that Dr. Ashbeck contradicted testimony, and therefore we ought not conclude it because there was a deposition transcript to which Mr. Leckie alluded. I found that to be an interesting argument because of the very argument being advanced on behalf or concerning Mr. Whiteman. In this instance, the affidavit preceded by some considerable time, I think 2 years at least, the deposition to which Mr. Leckie refers. And we could go through and parse the language of the deposition. I don't think it stands against anything that was set forth in the affidavit that Dr. Ashbeck prepared. But certainly, if we're going to look at anything in Dr. Ashbeck's testimony, I think we ought to look at the testimony, sworn statement rather, that he tendered while he was president of NSPC. And as for Mr. Whiteman, as we've acknowledged, Your Honor, these fees were not being collected by MMDS. And during a deposition involving a non-compete dispute concerning a Dr. Hasbargen that had left the group some years ago, there was some talk of the financial statements that would have impacted Dr. Hasbargen. And Mr. Whiteman was there, was subpoenaed to testify in that case and give a deposition regarding matters related to Dr. Hasbargen's separation. And what was particularly telling is the very section that were called out, in particular, if Your Honor looks to page 4 of the materials that Mr. Leckie presented, which is the testimony of Mr. Whiteman. The question to Mr. Whiteman starts as follows. On page 5, it indicates the monthly fee services equal to 7%. The suggestion and the argument advanced is that Mr. Whiteman was interpreting a contract during this deposition. He was not doing that, Your Honor. If we looked at the contract, the terms that we are discussing, the ones that I brought to Your Honor, those are on page 2 of that contract. There's no way to get all the way to page 5. With page 5, if we look back earlier in the deposition transcript, it's talking about financial statements. And these are financial statements that they're going through. He's being asked to interpret. And he is testifying as to what has been taken out. He's not offering an opinion of what his contract says. He, at that time, he hadn't examined his contract. Number one, he's not competent to give a legal opinion. If Mr. Leckie will confer that competence to him that is binding upon us, Mr. Whiteman has opinions about lots of things, legal opinions, and would be very happy to have legally binding upon NSPC. I'm sure Mr. Leckie's not about to agree to that, and certainly everyone here in this room knows that a layperson without the proper legal training is not competent to offer that advice. So even if he thought that was the case, even if he read the contract, it is of real no moment. It's of no moment here. That is Your Honor's exclusive jurisdiction to decide what the contract says. But he wasn't talking about the contract. He wasn't interpreting it from the contract. He was giving evidence or giving testimony concerning how certain fees were collected and how they were dispersed to the individual physicians in a case involving a non-compete allegation or an alleged breach of a non-compete covenant. So to suggest that Mr. Whiteman is contradicting what he said in an affidavit, no, he is not. And he's gone through in great pains in that affidavit. Mr. Leckie cites to one passage of Mr. Whiteman in that affidavit. What happened is Mr. Whiteman says, no, I wasn't collecting these fees. But after they filed the lawsuit, I conferred with counsel. I looked at the contract, and he goes through the progression that I've laid out for you here. So we ought not just dismiss his affidavit. There's no basis to do that. Even if it was directly contradictory, which it is not, we're talking about interpretation of financial statements, not contracts, that is explained even by his, I learned more information as I went forward. We don't lock somebody in time to what they said 10 years ago and say that applies forever. If there is a distinction, if there's a dispute or something varies in what they may have said, that is something that would come into court, put the witness in the chair under oath, and find her back and determine whether that witness is now accurate now, was accurate then, or some variation in between. But it's not as though we just reject out of hand an affidavit, which going out in the court, and I know the court is well aware, we're in a summary judgment stage. We're not held to the rules of evidence right now. Affidavits are how we go forward in this type of proceeding. And we know that a motion for summary judgment is not the appropriate means for resolving questions of credibility of evidence or its weight or even conflicting inferences. That's from the LakeCo versus Durholtz claim cited in our brief. We know that from Bassett and Glock that summary judgment must be applied with extreme caution. This is not a case that is properly before the court for summary judgment at this stage. There are probably course of dealing issues that we ought to take up. There are disputes where NSPC's own physicians have said this is patient-related services. The contracts are quite clear. In terms of contracts, are really all that we ought to be considering right now. There's no basis to consider parallel evidence. Not from Mr. Whiteman, arguably not from, I'll say it, not from Dr. Ashbad, certainly not from NSPC's claims. The terms of the contract are clear, definite, concrete, and they don't call upon us to resort to extrinsic evidence. There's no parallel evidence that should be introduced at this point. We should be looking at the terms of the contract. The terms of the contract are quite clear. Those two blue boxes that I've outlined before the court tell us that. And I've set forth, I won't go through the litany here. We know we're governed by the four corners. Your Honor's had, I'm sure, a million of those cases. I can give you litany of cases that say, we look what's in the four corners of those documents, and it's up to the court to interpret those agreements. It's clear and unambiguous that the fees were to be paid for professional services rendered to patients. It's not appropriate at this time to grant any sort of dispositive motion concerning this issue. MMDS acknowledges that we probably have a course of dealing argument, so if we came forward to you before today, we could say the contract says this, but they're going to eventually want to make a course of dealing argument. So we recognize that would be a waste of the court's resources. But certainly, we ought not be before the court right now trying to resolve something that has a lot of facts in dispute, has nuance to it, but the basis for which the motion is advanced is quite clear. We look at the contract, and if we look at the contract, strictly the contract, the judgment should be in favor of MMDS.
Okay.
Thank you.
Remember, just a few points to make for NSBC and rebuttal. I appreciate that MMDS is scrambling a bit here to create an issue of fact. Let me go through each one of these arguments just very briefly. On this idea that Mr. Whiteman, the president of MMDS, did something, I think we just look at the testimony here very clearly. The monthly services is 7% of all the clients' monthly net collection of fees for professional services for participation. That is the very provision, this is on page 49, that is the very provision that we're here to talk about with respect to NSBC and MMDS. I don't know what the exhibit was exactly, why it said page 5 instead of page 2, but the question recites the very language of the provision of the contract. And the question is to Mr. Whiteman, how is that 7% calculated? And he makes it very clear. These collections are anything other than medical director fees. The idea that the contract doesn't say what it exactly says, which is you only get a percentage of fees rendered for services rendered to patients, that doesn't hold any water. The idea that we're adding words or want to take out words to this contract isn't right. What MMDS wants to do is they want to add in, they're the ones rewriting the contract, they want to add in, oh, and on top of that, we get a percentage of all the medical director services that you render, not the patients, that you render to the VA. To that point, Your Honor, MMDS provides a page of the DaVita medical director review. MMDS is right, we didn't attach that to our motion. We thank them for attaching it to their response, though. As Your Honor reads through these, what are the services that are detailed here? These identify services rendered to the center, the dialysis center. For instance, you're to assist the center in ensuring that the center patients and treatment plans are monitored for periodic assessment. You're to assist the center in ensuring that all long-term and short-term care plans are completed. You review and assist the center. You assist the center. It goes on and on with that type of language. That exactly lines up with how the Medicare regulations distinguish between medical directors and the services that they render to the center, to DaVita, to third parties, and the services that are rendered to patients that are then paid for through insurance carriers or through the patients directly. The contractual relationships are vastly different. Third, Your Honor, MMDS raised the issue of Dr. Arpin's testimony. As Your Honor reads this, I think you'll see the very distinction that we've identified consistent with the Medicare regulations. In the testimony, they explained that technicians would actually go out into the dialysis center. They would prepare water reports based on what the equipment was showing. Those reports then were taken back to the medical director for a review of the center's controls. But you have the technicians who are in place in terms of monitoring the dialysis units. This is consistent, I pulled out of our brief, Your Honor, this is consistent with the Medicare regulations. Under those regulations, reviewing the water reports is an administrative responsibility. Exactly what we've been telling the court the whole time. This is not a service that's rendered to patients. They're not a treating physician. They are an administrator of the facility. MMDS also talked about Dr. Oshbach's affidavit and subsequent deposition testimony. I think MMDS has confused one thing that I want to clarify. We're not saying that Dr. Oshbach's deposition testimony is somehow inadmissible because it conflicts with his affidavit. We're saying his affidavit is meaningless because in his deposition he admits he doesn't have personal knowledge. He doesn't know whether medical director fees are included in the agreement for billing services between MMDS and NSBC or not. That's what he said in his deposition. He says, Your Honor, question. All right, so back to one of my original questions. The compensation that was due to MMDS did not include monies that the corporation, nephrology specialist, received for medical director fees, right? He says, answer, I'm not entirely certain. Question, you don't know one way or the other. Answer, that's correct. So, whatever Dr. Oshbach's affidavit, he wished it to say, under cross-examination and deposition, he conceded that he actually didn't have personal knowledge. So his affidavit's inadmissible. Can't be used to create an issue of fact. So, with respect to each one of the points that MMDS raises, there's a very simple explanation. Medical director fees are not the same as services rendered to patients. Medicare regulations recognize that. The services that are detailed in the medical director agreement, again, are directed to the center, services to the center, as opposed to services rendered to patients as a treating physician. And anything that Dr. Oshbach would say is simply inadmissible because he lacks personal knowledge. There's no reason, Your Honor, at that point to have created an issue of fact on this. The bottom line is the agreement is very clear. It doesn't include medical director services. The same thing about medical director services. The Medicare regulations understand there's a difference between those two things. And everyone from MMDS admits the same understanding that we have as to the agreement. I'm not sure what MMDS is trying to offer the court and saying, well, what's the dealing, we're talking about the agreement. You don't have to go to course of dealing because the agreement is very clear and everyone's testimony lines up. The Medicare regulations line up. It all leads the court to a single conclusion, and that is MMDS was not entitled to a percentage of net collections that NSBC collected except for services rendered to patients, not medical directors.
Okay. All right. We'll take this under advisement. There's an awful lot here. You waive 53? 53? You waive?
Of course, Your Honor.
Yeah, I mean, it shouldn't take me too long, but I don't want to run up against the deadline. I have one question. Now, these, so in other words, the doctor is a medical director. He would be paid. He also treats patients. So he'd be getting two separate payments, like one for treating the patients and one for being a medical director.
Your Honor, when they're acting as medical directors, they're not acting as treating physicians. Do these physicians, as part of the physician group, also act as treating physicians with privileges at other hospitals? Of course. Do they have patient billing and patient billing back then that MMDS would process with the insurance carriers or with the patients directly? Yes.
Okay.
Yes, they got remuneration for that. So we're not talking about, did they get properly paid for that type of stuff?
No, in other words, what I'm getting at is they got paid one fund for being a medical director, and then for any patients that they would also get paid for that.
That's correct. They were stated.
Okay.
But those services could not be provided simultaneously. There's an expectation that as a medical director, so much of your time is set aside for the medical director. Not at that time. Now, we say within that time, the services rendered to patients.
Yeah. And I think Mr. Andy's point is very good. They can't be rendered at the same time. There is a distinction, and that's a distinction between the two.
So they had to dedicate so much time of their day to being a medical director, and they couldn't treat patients during that time.
I believe that's right.
Okay. All right, gentlemen. I will get this.
Thank you, John.
All right.